Two ways the state could go. Or we can prohibit these technologies, or we can switch off the platforms in our territory, prohibit, yesterday we talked about it, augmented reality glasses. That would be a prohibitive way. This is the traditional way the law goes. Traditionally, the law says this is dangerous, and then it forbids. But if we forbid this technology, which is a global technology, we will switch off ourselves from the technological development, and that will on middle term have big impact to our economical situation. So this is not a way to go. So what way is to go? There is only one way. We must think about pragmatizing the law and find a more pragmatic approach to accept that nowadays the danger for the privacy, for example, is higher than before, and that the human netizen, the citizen in the internet world, must be more aware of that and must be more self-responsible for handling that. And maybe the modern people don't want to be protected that strictly anymore, like the people wanted to be protected in the 80s of the 20th century. However, that is the only way we can go. We can accept there is a limit for regulation, and we must accept that. We pragmatize the law. That will, of course, lead to certain danger for the citizen, but the citizen must be aware of that, must protect himself alone. But what is the other way to go? If we forbid something, and the prohibition is not working because it cannot be enforced internationally, then we have inconsistent law. And inconsistent law means a law which is there but not enforced. What worth is this law worth for? It will lead to trust of the citizen in the law because the citizen knows there is a law but nobody enforces it. I mean, ask yourself, right, about consumer protection. When I ask you how many of you think that the consumer protection law is really strictly enforced in Indonesia, not really, right? But you have a modern consumer protection law. However, in Indonesia are modern laws but not always enforced. So how is your trust in the law? This is how can I say, an erosion of the national law and of the trust in the law.
Ya, jadi kalau misalnya kita kembali kepada pemahaman tradisional hukum, biasanya kalau terjadi sesuatu yang dapat berdampak kepada masyarakat, maka itu harus dilarang. Tetapi apakah jawaban yang benar kalau misalnya kita harus melarang perkembangan teknologi? Maka kita akan menjadi tertinggal terhadap hal tersebut. Sehingga apa kira-kira hal yang dapat dilakukan? Menurut Prof. Stefan, kita dapat melakukan pragmatisme hukum, di mana kita akan menerima perkembangan teknologi ini, tetapi juga membatasi aturan hukumnya dan juga membangun kesadaran masyarakat.
So some states can enforce the law still, yeah, like European Union, like the US. We talked about this yesterday, but not everybody was there. And that is exactly the crisis of the international law, which I mentioned already. Because if a bloc like European Union or United States can enforce their protection of the citizen extraterritorially, then they cannot do that because the international law gives them the opportunity for that, the option for that. They can do that because of political and economic power. This means we have the law of the strongest. And that is a factual, this is a political principle. A political principle replaces the legal principle of the international public law, of the sovereignty principle, and of the courtesy between the nations. And this is a part of a self-defense of the blocks or of the states. I cannot go more into the deep, but this is actually a big crisis for the systematic of the international law.
Jadi sebenarnya ini juga merupakan salah satu bentuk dari krisis di dalam hukum internasional, di mana kalau Uni Eropa sendiri dalam politik perekonomian mereka dapat memaksakan hukum mereka secara ekstra teritorial, sehingga prinsip politik ini dapat menggantikan prinsip kedaulatan dan lainnya yang disebutkan tadi.
So just to close this part of my presentation, you see I already shortened it. Privacy by design, that would be one of the solutions for protecting the citizen. So if we cannot really control what platforms do with our data, we can at least force the products to be produced in a certain way that we control the product is able to do so or not. This is something which should be considered more. So the privacy by design of the product will be more important in the future, especially in the data protection law. So About the replacement of the trust, this is a book from Niklas Luhmann, Das Recht der Gesellschaft. It's a very classic book about the sociologist Niklas Luhmann, and he argued that for societies in which the law is not able to protect the citizen enough or not willing to protect the citizen, the society will search for different instruments, for alternative instruments for protection. This means if we transfer that to the modern situation with the technology, which are replacing the trust in the law, then it would mean that the society will look for alternative mechanisms and alternative instruments which replace the instrument, the protection instrument of the law in the society process.
Jadi ini adalah satu buku yang ditunjukkan oleh Prof. Stefan, di mana buku ini merupakan buku yang menggunakan pendekatan sosiologi. Di buku ini menyatakan bahwa apabila masyarakat tidak lagi dapat mempercayai hukum dan tidak dapat mendapatkan perlindungan hukum, maka mereka akan mencari alternatif lain untuk mendapatkan perlindungan. Maka dalam hal ini bisa jadi digital itu menjadi salah satu peralihan kepercayaan tersebut.
Now I would like to show you several examples of the modern technology of the digitalization, where we see that the human factor, and with the human factor the trust aspect, is replaced already or at least diminished in the modern law. So one of the factors is the artificial intelligence, and artificial intelligence, we have the presentation already. Artificial intelligence for me is very interesting because the law, and here in my part of the civil law, we have a strong behavioral focus. Means we have behavior in contracting. Contracting is an instrument based on trust. I make a contract with you because on one side I trust you, on the other side I don't trust you. And I make the contract to be able to document what we agreed. And I trust in the system because later I can go to the court and make the court force you to pay the money out of the contract. So you see, contract based on trust, and contract based not only on trust, but contract also is based on private autonomy.
Ya, jadi ini ada satu contoh yang diberikan oleh Prof. Stefan, di mana sudah terbukti kepercayaan manusia itu sudah terhadap hukum sudah tergantikan kepada teknologi. Contohnya misalnya artificial intelligence yang sudah dijelaskan tadi, di mana ketika seseorang akan membuat suatu kontrak, biasanya kontrak itu selalu didasarkan pada kepercayaan. Tetapi menurut beliau tidak hanya kepercayaan, tetapi juga private autonomy atau kewenangan seseorang untuk melakukan sesuatu, sehingga orang akan mempercayakan kontraknya melalui AI, dan ini dapat dibuktikan di pengadilan.
Now, before we go to the contracts, we go to another aspect of behavior, and that is in the antitrust law. Antitrust law is correcting or is controlling behavior in markets. So, if you behave abusing dominant positions, or you behave, you make an agreement which harms the freedom of the competition, and that is behavior. We make a sanctioning of market behavior. Now, some years ago, there was a case where German airline Lufthansa was suddenly raising all the prices for domestic flight tickets after the bankrupt of a concurrent airline, Air Berlin. So suddenly, within seconds, the price of the tickets were up. Now the German KPPU, das Bundeskartellamt, was investigating the case, and Lufthansa said, no, we did not do anything wrong. We did not even do that. It was our artificial intelligence system which is observing the market and reacting. And reacting is not forbidden, and we did not even act, so we did not behave. And the Bundeskartellamt had to let the case fall down.
Ya, jadi contohnya misalnya di dalam antitrust law ya. Jadi pernah terjadi di Jerman harga tiket pesawat yang tiba-tiba sangat naik drastis. Kemudian pemerintah Jerman melakukan investigasi atas hal tersebut. Tapi ketika perusahaan ditanyai, perusahaan menyatakan bahwa itu bukan merupakan ulah perusahaan, tetapi lebih karena AI yang ditanamkan yang membaca market yang sedang turun sehingga harga naik, sehingga kasus tersebut tidak bisa dilanjutkan.
It shows very clearly that we need a new concept here. Yeah, Because, an action which is just reaction to the market action of another actor is not forbidden. Of course I can observe the market and can raise the price. The problem here is that it is so fast that a human market actor cannot compete with that speed. So this is the one factor. And the second factor, it shows very clearly that in the future, everything which is abusive can be done maybe by AI, and then no human being will be responsible for that. And that means the antitrust law will go to the empty space and will not really help anymore to keep the markets open.
Ya, sehingga kalau dari contoh kasus tadi, maka itu sangat penting bahwa dibutuhkan adanya konsep yang baru. Dan pada masa depan nanti, setiap pelanggaran itu justru akan dihandle langsung oleh artificial intelligence, sehingga hukum antitrust itu mungkin saja tidak lagi dapat berlaku.
Several solutions are discussed for that. For example, personification of AI. I cannot speak about that. That is already another topic. How we personify an AI. Can AI be a legal person? Or assign responsibilities to the one who is the one who has the success out of the action of the AI. So I use the instrument, so I'm responsible, whether I did it or not, whether the instrument is autonomous or not. So I'm the one who has the advantage from acting. These solutions can be discussed, but we want to end here with that point.
Ya, contohnya misalnya seperti personification of artificial intelligence untuk dipertanyakan apakah hari ini dapat diperhitungkan sebagai salah satu subjek hukum.
Contracts by AI is for me the most important point because it shows that we have a paradigmatic change in the constitutional basis of the law, of this private law. Because AI is not able to wish and to long for something. But if I make a contract, I make a will. This is a contractual will I put into the contract. And why I can do that? Because it's based on the private autonomy, at least in our legal system. And the private autonomy, again, is based on a freedom concept. And that freedom concept is regulated in our constitutions, and in the end it comes from the human dignity. So the freedom of making contracts and putting my will, my free will, into a negotiation system and then into a successful contract is part of my personal freedom. Now, what happens if AI makes contracts? Smart contracting, yeah? So we program the AI, the smart contract, and when something happens, some condition happens, then the smart contracts will execute automatically. Or we have two AIs, and these two AIs make a sort of a negotiation, but actually this is very determined. Of course, the AI can be programmed to make a contract offer in some certain condition, and the other AI can be programmed to accept the offer. Is this a contract or not?
Iya, oke. Kalau misalnya manusia membuat sebuah kontrak, maka akan didasarkan pada salah satu freedom of contract, kebebasan untuk menentukan kontrak, di mana kita menuangkan segala kehendak kita di dalam kontrak tersebut. Akan tetapi, bagaimana kalau misalnya kontrak tersebut dibuat oleh artificial intelligence, di mana dia yang akan mengeksekusi pada akhirnya kira-kira nanti akhir dari kontrak ini apakah menerima atau menolak.
First of all, a smart contract is nothing else than a vending machine. You put a coin into the machine and the cigarettes come out. But if it's combined with an artificial intelligence system which is flexible deciding, then it is very close to the human contracting. However, it is not human contracting because it is not free will. Now, if we make just pure analogy here, then we have a big problem because we leave the constitutional basis of the personal freedom and of the private autonomy. We accept contracting without private autonomy. If we want to do that, it is very dangerous because we leave the constitutional basis of the private law. So in my opinion, if we want that, and we must regulate it in an extra way, and we cannot do that before we don't decide about assignment of responsibilities for machine acting.
Ya, jadi kalau misalnya di dalam smart contract, apabila itu dilaksanakan oleh IP atau artificial intelligence, maka sudah jelas kita meninggalkan prinsip freedom of contract yang sudah tertuang di dalam konstitusi. Tetapi apabila kita tetap menginginkan untuk menggunakan AI, maka dibutuhkan adanya regulasi yang lebih yang dapat ditujukan kepada pertanggungjawaban terhadap mesin.
This aspect here is very close to the aspect of my colleague. Because here we talk about AI deciding about us. Yeah, AI deciding about us. Actually, everything is very close to that. Your self-driving car decides whether between the hard goal and the soft goal. I mean, my car is maybe heading to a wall. My car knows when it collides with the wall, my driver is dead. But there is an Ebu on the street, and the car knows if I collide with the Ebu, my driver will survive. So the car decides I kill the Ebu and not my driver. Actually, yeah. So this is actually a question of liability, yeah. And here we have something very similar. The AI decide what I can speak out in the internet. The AI is the filter. We have now in the European Union copyright law regulation, which force the companies, the platforms, to filter the uploads against hate speech or copyright infringements, especially. So it will, the AI will check out whether the snippet what you want to upload in YouTube is already known somewhere, and is there a license, and if there's no license, then it will not allow you to upload. That means an AI decide about my free speech, and the dimension is big because the free speech is an important fundamental right. This means technology decides about my fundamental right, about my fundamental freedom.
Jadi intinya adalah bahwa AI sesungguhnya dapat bekerja untuk memutuskan mengenai diri kita manusia, kebebasan kita sebagai manusia. Memang kita manusia yang akan menginput terhadap sistem di AI, tetapi AI yang akan menentukan apakah kira-kira hal itu dapat dilakukan atau tidak. Sehingga apakah ini nanti akan masuk ke dalam pelanggaran atau tidak, sebagaimana contoh tadi, kalau misalnya mobilnya dalam keadaan ngebut menabrak seseorang, apakah kira-kira nanti siapa yang akan bertanggung jawab di situ? Apakah AI-nya, mesinnya, atau orang yang punya mobil?
One more aspect, which is belonging to you students. I mean, you know you should not make plagiarism, right? So, if you make plagiat, I will find out because I have AI, yeah? I put it to the Plex scan and then I will know maybe, yeah? But I read now that there is now AI developed which can write your master and bachelor thesis all alone. You give them some data and it makes a text which is not identifiable as an artificial text. This means in the future we will maybe have master thesis and bachelor thesis, and we have to find out to detect whether that is written by AI or by yourself. If it's written by AI, it's not your work, it's not your effort. So and you cannot say this is a plagiat because the AI is so clever that it puts snippets so together that the Plex scan will not know this is actually put together from a lot of sources. This is the future challenge, and this we have already because there is already text processors which can write fake news, and these fake news sound very, very, very authentic. Yeah. And it's just written by some AI, and the AI is so sophisticated that it knows exactly how to put that so it sounds serious. And yeah, this is maybe the biggest challenge for the future. What will we do then? My colleague Bone from University of Dortmund said, no problem, then we don't have to correct it anymore, and then we have less work. Yeah, but it cannot be a solution, right?
Ya, jadi tadi Prof. Stefan menyampaikan bahwa sekarang itu sudah mulai dikembangkan salah satu teknologi dalam artificial intelligence yang dapat membuat sebuah karya tulis ilmiah atau penelitian. Jadi kita hanya perlu menginput datanya saja dan itu akan langsung diolah oleh AI-nya. Dan itu masih belum bisa didapat dideteksi karena berdasarkan perkembangan teknologinya, ini kira-kira yang bikin AI-nya atau manusianya gitu. Dan itu juga tidak dapat diklasifikasikan sebagai plagiarism.
So let's come to some consequences. We see here very clearly that interpersonal trust will lose relevance. So in the smart contract we can see that very good. I have a doctorand who writes about what will the blockchain technology do to the dispute settlement in the courts. Do we need the courts in the future? We will not need the courts in the future when it comes to the execution of contracts, because the contracts will be determined. We will need decision by courts, and we will have a shift of liability cases to the programming of the contracts. In the programming will be the mistake, the fault. If the programming is wrong, the smart contract is executing in the wrong way, but the smart contract itself is no problem. Why this is important? This is a displacement of technology for the loss of trust, because you can also use this internationally. How? Because if you internationally have the problem of copyright, for example, someone copies my text in the internet, and how I can make sure that I get my royalties from a Chinese infringer when I'm in Germany. In the future, it may be by the tokenization combined with certain smart contracting licensing that we have ubiquitary licensing, and the smart contract will notice, using also the technology of the blockchain, who is the owner of that copyrighted text, and then they will be automatically executed, the license, and the money in Bitcoin will come to my wallet, without any use of Chinese courts or German courts. So we do not need anymore maybe these courts with human trust in the law and in my contractual partner, because I don't need my contractual partner. The smart contract will do it automatically. This is a replacement of technology to replace the law and the human factor.
Ya, jadi interpersonal trust atau kepercayaan antara manusia itu akan digantikan atau akan hilang dan sudah tidak relevan lagi ke depannya. Misalnya contoh kalau dalam konteks tokenization, misalnya berkaitan dengan copyright yang diambil oleh Cina, misalnya itu biasanya kalau dalam paham tradisional itu bisa dilakukan melalui pengadilan. Tetapi dalam perkembangan teknologi, smart contract juga dapat digabungkan dengan tokenization, sehingga apabila ditemukan di dalam digital tersebut bahwa telah terjadi pelanggaran, maka akan secara otomatis smart contract akan membawa pembayaran atas copyright tersebut kembali kepada akun
blockchain
yang dimiliki oleh.
Is an instrument of trust. This is a ledger instrument, a trust